Okay, so we should be live. All right, go ahead, Anthony. You can go ahead and ask me your question.
All right, here's the deal. I'm dealing with another biopic. I'm working with a guy who's a manager, and he told me to do a memorandum of understanding with the museum. Okay, this person had a book out. That's an autobiography. It was released in 1956, so I don't think it's right meets the threshold for public domain. I think it's 70 years after publication, right?
That sounds about right when it goes into the public domain.
Right, 70 years. So it was 1956. So it's not quite there yet where I can use it public domain. So he told me to do a memorandum of understanding to the museum.
Okay, so as far as the memorandum of understanding to the museum,
Right.
the publisher wants you to obtain a memorandum of understanding from the museum. First, let me just.
No, the manager, my manager, well, not my manager, the manager that I'm working with.
The
He
manager.
hasn't signed yet.
Yes. Well, first, overall, the more agreements you can get in writing, the better. Okay, this is called your chain of title.
All right.
That is your contracts, basically releasing of claims on your title to the work or anything that could be a cloud. A cloud basically means any possibility of a lawsuit. Now, a memorandum of understanding, all because it's not labeled an agreement, it can still be effective as a contract. It does not matter what you call the document, all right, as long as it meets the elements of a contract, which is an offer, an acceptance, and consideration, okay? Mutual assent, meeting of the minds, reciprocal bargain for exchange. As long as those elements are met within your dealings with the museum, you have a contract. And your manager wants you to get a memorandum of understanding because they want some security that the museum is not going to file a lawsuit, probably because you're using some depictions, some work, some photographs, possibly from whoever the subject may be that is portrayed in the museum. Now, the museums do usually acquire a lot of rights, so you probably will need to get a release. You may want to look on the museum's website. They probably have a clearance type link that you can contact, an email, or someone who's in charge of licensing. Okay, that's really what your manager is asking. He wants to protect the chain of title. Does that make sense? You with us, Anthony? You're on mute.
Can you hear me?
Yes. Did you follow what I said?
Yeah, I do understand that, but I was concerned because I don't have to go to the publisher for rights to the book. I can just go to the museum.
Well, the museum may have acquired the rights. If the museum is depicting the book, it's a book now that what you're trying to acquire rights that you're using. And my answer is going to be this, Anthony. You should get them from both. You have to protect yourself.
Okay.
Now, who is the actual rights holder? If they're both claiming rights to it, that's a dispute. But if you protect yourself and you get clearance from both of them, you're in the clear. Does that make sense?
Okay.
Yeah, there
may
be, in fact, a dispute as to who owns all the rights to the work. The museum or the publisher. That's often a dispute. And what rights do they own? But I would try to acquire releases from both.
Okay.
Okay.
All right.
Does that make sense?
Okay. And I don't have to have consignment with these memorandums of understanding, like a payment.
Okay. Consideration. Now we're getting to consideration. What is fair and reasonable consideration? And license agreements can be free. They can be $1 or they can be quite expensive. All right. It all depends on the owner and how they're offering their work to be used by others. Now, that is not to say that you don't have the defense of fair use. You always have that defense of fair use, something you can rely upon, but you want to proceed in good faith. One of the factors as to whether fair use will be applied is whether you proceeded in good faith. And proceeding in good faith means making the attempts to license the work. So document, and always when you send these correspondence, always keep a copy for yourselves. All right? It never exists if you give something and you don't keep a copy. You don't give something without keeping a copy. All right? You bear the burden of establishing that chain of title, your documents and your attempts, all right, to establish good faith. So keep everything, all correspondence with the museum and with the publisher. I may have digressed. What was your question?
Oh, no. It makes sense now, just get as much paperwork as possible, no matter who.
Mm-hmm.
So get it from the museum and maybe even try to get it from the publisher.
Yeah.
And as far as consignment, as much as being reasonable from myself.
Okay, I want to stop you for a second because you're using wrong terms. And it's important that you use the right terms. And I know legalese is a different language. But when you're saying consignment, I understand. I know what you mean. You are referring to consideration. It's not consignment. Consignment has a different meaning. It is consideration. Consideration is reciprocal, bargained for exchange. That is what is given for something in return. It is a legal detriment and a legal benefit to each party. In each binding agreement, there must be consideration. You must have a restatement that consideration has been provided. Yeah, there are license agreements that are basically free, that are given without a charge, or sometimes even for just $1. They will reiterate the consideration provision in that agreement. For fair and reasonable consideration, receipt hereby acknowledged. That is the language you want to use, especially if you're doing something for free, that there's not going to be an exchange of money. Now, consideration does not have to be money. It's reciprocal bargain for exchange. So as long as you reiterate that consideration hereby acknowledged and received, you satisfy the consideration element, because it could be the notoriety. It could be the secondary benefits they receive by allowing someone else to use their work in another work. All right. So consideration is quite vague, and the courts will not get into subjective value of consideration, but it must be something more than just a mere. It must be something more than just a farce. All right. It must be real. All right. So there must be real consideration. But you'll see those terms presented in agreements, and in your memorandum of understanding, you should also reiterate the consideration clause. Okay? Does that make sense?
Yes.
So yes, it can be provided without money. There are licenses done without fees all the time. All right? But there are also license agreements that are quite expensive. You have to reach out to the rights holder and contract for it. When you're dealing with intellectual property, all right, creative works, ideas, mental labor, intellectual property, everything must be in writing. And to go a step further, must be in writing, signed by the party to be used against. Okay.
Okay.
All right. Well, we do have some people that are watching on live. If there's any questions they want to put in the chat, feel free. I believe I should get those messages. But the key here, Anthony, is to document and save your records. All right. So many times do I speak to people and they said, oh, I sent that letter, I sent that correspondence, or I made that report. And I always inquire, do you have a copy? And they said, no, I just mailed it or I just submitted it. I'm like, well, it doesn't, practically speaking, it doesn't exist. If you do not have a copy for yourself to use to support your case, we can't rely on the other side producing anything that's favorable to you. We have a burden to present your case. Okay. And I think more in terms of a plaintiff bringing claims, proving your case, because that's my client base. I work for plaintiffs generally. Okay. Uh, and I say generally because even if I'm presented with a defense matter, if you're put on the defensive, I do not go into a dispute, which is an adversarial setting, which if you take it further, it's a battle, it's a fight. There's two opposing sides. It's an adversarial setting. All right, whatever the dispute may be, contract dispute, a civil dispute, it's adversarial, and we do not go into an adversarial setting, a battle, just on the defensive, just on the shield. You have to be able to support your side and be on the offensive and have a sword. Always, you have to even claims out. All right, you must always assert claims and your rights against the other side, even if they first assert their rights against you, because the claims will eliminate each other. Or perhaps you have a stronger claim and you're in a position to actually win rather than to solely be on the defensive, where your only outcome is basically a dismissal of a dispute or a loss. There's really no win. Does that make sense?
Okay.
Yeah, just, to keep it basic, keep all records. And in your situation, because it also has a benefit to show your good faith. Very important in your setting to show good faith in acquiring rights. That means writing and saving those letters and inquiring as to who is the rights holder. All right. Does that make sense?
Yes.
Because that will support your position of fair use later on.
Okay, great. All right, so I got to go and find a template for a memorandum of understanding and then get that out and make contact with the museum today. All right, great. Thanks, man. I appreciate it.
Yeah. Look, there, a memorandum of understanding is not really a standard document. It really isn't. You probably won't find anything template about it. It is very customized. I mean, what is the understanding between the parties? All right. And that's very subjective to your dealings. Because I know the specifics, if you're referring to the museum, again, I would go on the museum's website. They probably have a licensing department. It's not uncommon for creators to use the works in museums because they are historical. And so that's where you acquire a lot of these rights. And they do have licensing departments.
Okay.
All right, man. Yeah, thanks. I appreciate it, Justin. Let me look. I'm on the website right now, so I'm going to look at it and see what I can come up with.
You probably should give them a description of how you will use it, and also still assert fair use and saying in the alternative, if we can't reach an understanding, start asserting your fair use rights now. All right, you intend to use it this way in compliance. Remember, I gave you the statement, the independent filmmaker statement on the practices of fair use. Refer to that. All right, that is a authority. All right, you have that statement, right?
Yeah.
Okay.
Wait a minute. I'm sorry. Statement of authority.
No, the statement of by the independent filmmaker's statement on the practices of fair use.
Oh yeah, you gave that to me a while ago, right?
Yes. It was
Yeah.
issued by I believe, the Washington University of Law, I believe. We do have a message from Denise in the chat regarding a tort claim that was coerced and into settling. I do have to make a disclaimer here. We are live. We have third parties. There is no confidentiality in these Zoom webinar meetings, Q&As, just general questions. Any specifics, we can schedule a confidential consultation. There is no confidentiality here, and there's no attorney-client privilege, which is the crux of an attorney relationship. So I do encourage everyone to reach out to speak confidentially about their specific matters, but I am open to answering general questions. And I think Denise put into the chat, I don't know if she can log on to ask me directly because it's tough to get into the question. If you can elaborate more in the chat without going into specifics, that would be helpful, Denise. We'll give her a moment. But back to you, Anthony. Is there anything I can clear up for you?
Not right now. I'm going to continue to reach out to the museum, and then I'm going to ask them, would they be comfortable signing a memorandum of understanding so we can, start a relationship, a working relationship to maybe create a project.
Yeah, open the door of dialogue.
All right. Yeah, I will. All right, great. Thanks. I got to sign off.
All right. Thank you, Anthony.
Bye.
We do have 3 people live. So just to address this tort claim matter, coerced into settling. Well, that's a difficult situation because when you sign a settlement agreement, it is usually voluntary. So it's difficult to argue that you were coerced into settling. But a settling agreement is just that. It's another type of agreement. If there was any form of fraud, coercion, or duress, but it's very difficult to prove duress. It must be under severe duress. Basically, someone who's, although your attorney pressured you, that's not a legitimate reason. Okay. Now, if you disagreed with your attorney and your attorney went ahead and proceeded with doing something to which you did not agree with, and that is memorialized in your correspondence against attorneys, in your correspondence with your attorney, now your recourse may be to either have some type of action against your attorney. It's very difficult to prove malpractice. It's a high standard, professional duties. You may want to speak to a specialized attorney who handles those type of cases, legal malpractice cases. I personally am not in that business, and I couldn't really advise you. But there's also the state bar you can reach out to. Attorneys are fiduciaries. They're in a position of trust. They must communicate with their clients. And ultimately, it is the client's case. It is the client's decision, all right, with the input of the attorney's counsel. Now, if the client is the attorney are at an impasse and the client is not listening to the attorney's advice, then the attorney may have a duty to withdraw. Okay, so that is your recourse there. As far as I'm aware, I would encourage you to book a confidential consultation. We can go more into specifics. A lot of times when people bring up an issue, it's really not the issue that they believe it is, and there's other issues that may come involved and other avenues of recourse. And so that's why it's important to consult with an attorney for legal theories of liability and courses of action. So I encourage you to reach out. And if I can't help you, I'll do my best to get you to a referral, an attorney who can. I want to give it a moment. There are some other people on the live feed. If anyone has a question, please put it on the chat. Let me check the Zoom to see if anyone's logging on. I have not checked that. But yes, this is Coffee with a Lawyer. We do this every Monday, 9 a.m. It is my way of being of service to the community and just being able to be in touch and be of service. So if anyone has any questions, please put it in the chat. If not, we will sign off and we'll get our week started. Everyone take care, take action. Every Monday, 9 a.m., Coffee with a Lawyer. We can touch base, be accountable, and answer any legal issues you may have. Thank you very much. Take care, take action. Have a good week. Bye-bye.